at Samara University, but now I'm working in the field of contract law at NNK. It's part of Rosneft Group as a senior legal counsel. And first of all, I would like to meet you. Please tell me your name, tell me where you're from, and why are you learning in international school today? Yes, of course.
My name is Sabuhi. I live in Mingachevik city, Azerbaijan. I am a teacher of English. I learn international law for my new career.
Great,
In
great.
my new career. Thank you very much.
Yeah. Please, next.
Hi, my name is Priya. I'm from Switzerland. I'm also a law student, but I'm still in my bachelor's. And I chose this law school, this international law school program because I just wanted to learn another perspective, another country's perspective. So that's why I'm here.
Thank you.
Hi, my name is Leonardo Raúl. I'm from Mexico. I have a degree in international relations, and actually I'm working as a professor in international business and also in UNICEF. And I take all as Priya this diploma for have a new view from other country, new perspective, new ideas, and that.
Wow, great. So today I have the best class that I have ever had. I really thank you that you are today here, and now at the Samara it's 8 p.m. So if you're going to be bored with my lecture, please tell me, because it's I understand you, because I have so many law schools, and my last law school was at August a year ago. It was ICLRC. It's one of the biggest international centers in Russia, and it was really hard to work 2 weeks for all day, and that's why we was so tired every time, and we was overwhelmed with homework. But you are lucky, I don't have homework for you, just only a lecture of theoretics of international economic law. And I guess maybe we going to start. First of all, unfortunately, the pandemic has stopped us from getting to know you in person. I hope you really like the international school anyway, and you are getting the experience that you've come for. And today here we will discuss international economic law, as I said. But before we start the lecture, I would like to ask you one more question. Have you ever been in Russia?
No, I haven't been there.
No. Okay. And other scholars?
No, I haven't been to the respected Russian Federation.
Oh, yeah. And where is Raul? I guess
I think he has bad connection.
Connection is not the best. Okay, let's. I think we maybe have 1 minute to. I have to prepare my presentation, and maybe Raul will come for us. Do you see my presentation?
Yes.
Okay, great. And now to sorry, some technical problems. Do you see the presentation? Yes? Yeah. Okay, that's great. And okay, let's start. And let's start. But the aim today's lecture is to, first of all, to analyze the international economic law and fundamental principles. I will examine the current framework of international economic law and the efforts made to regulate international economic relations between states and as a part of attempt to establish a global order and global order between the countries. It will begin by surveying efforts made prior to the establishment of the United Nations, and will then focus on the developments that have taken place since the establishment of the United Nations. The objective of our lecture today is to provide a comprehensive, critical appraisal of the law developed to govern economic relations between the different states and between states and private economic actors, such as multinational enterprises. So, international economic law, let's work. International economic law is really massive body of law, which is growing rapidly, changing fast in the modern times. It seeks to regulate more or less all aspects of international economic relations between states. And international economic law developed as a separate and identifiable body of the all international law and or in the post-Second World War era. Prior to this, the law relating to the international economic activities, also protection foreign investment, was a rudimentary stage of, was regarded as a public international law. The Bretton Woods institution, first part and first historical part of the international economic law, were set up in 1944, which are the World Bank and the International Monetary Fund. And the aim creating of these institutions was based on notions of consensual decision making between the states, and also about the cooperation and trade and economic relations. A multilateral framework was necessary to overcome the destabilizing effects of the previous global economic depression, trade battles, and to help to rebuild shattered post-war economy, and to promote international economic cooperation between states. After the creation of Bretton Woods Institution was the General Agreement on Tariffs and Trade, also known as GATT. And it was established in 1948 with the view to eliminate harmful also trade protectionism from other countries. Sorry, I have some technical advices from the other organizers. Sorry. Mari, is it working now? Yeah, okay. I will set the text from the organizers. And also, the Bretton Woods was and GWT was replaced by the more robust, and now you know about this organization. It's called World Trade Organization, or WTO, in 1995. Also, today we will discuss how economic relations between peoples, between you and me, between other peoples and countries have developed over the time, giving rise to new challenges in the law. Much of international economic law has developed relatively recently in response to the growth of international economic activity. As the expansion of international economic activity increased contacts among people, different nations, this interaction had to be regulated by also international law. In the early years of the development of international economic law, the law dealt mainly with the nature of the legal relationships between states, foreign companies engaged in the exploitation of its natural resources. It is in this context our lecture will examine the evolution of select key principles of international economic law. Also, we'll examine the definition of the international economic law and the body of the law and developments in the areas of the international law that have influenced the development of also international economic law. But firstly, I would like to start from the sources of international economic law. Sources of international economic law are also sources of general international law. And is codified in Article 38 of the Statute of International Court of Justice. This article generally regarded as providing the most authoritative listening of international law sources. Firstly, treaties. Secondly, international custom. Thirdly, general principle of law. Fourth, judicial decisions of international courts and tribunals, and also teachings of the most highly qualified international lawyers. But it's used as a subsidiary means for determining the rules of law. Treaties have the preeminent role in the development of international economic law. But the practice of states is also important. The practice of states acquires the character of the customary law when a particular practice meets the test of generality, uniformity, consistency, and is coupled with legal convictions on the part of states that are obliged to follow by the law. And this psychological element is called opinio juris. But now we are going to the antiquity. We will start now from the history. And when I said the antiquity, I mean ancient past, which especially refers to the period of classical and other human civilizations before the Middle Ages. The empire generally refers to an extensive group of states or countries under a single supreme authority, or a larger commercial organization owned or controlled by one person or the group. Since time immemorial, the first and the foremost objective of the law has been to maintain law and also order in the society. When people in antiquity begin to organize themselves as a societies on the basis of some rules to govern their activities of the members of the society, the primary occupation of the law was to maintain order. But from its outset, the legal system of society advanced civilization by maintaining law and also creating a mechanism for settlement of disputes through the third-party involvement. This prevented members of the society from taking the law into their own hands and relating individually for any alleged injustice meted out to them by the other members of society. Those not content with the basic objectives of the law begin to expand its role by using it for social engineering, the view of advancing civilization, promoting justice, both social and also the most important, the economic, and achieving the greater prosperity and happiness of all members of the society. And since time immemorial, people have endeavored to create wealth and to surprise the older generation in attaining higher standards of living, prosperity, and happiness. And this led to some venture out of their local communities and interact with people from the communities for trade and commerce. The level of interactions grew as science, technology advanced. New modes of travel made it easy for explore and adventurers to travel out in their missions to faraway countries. Traders then followed them. Thanks to the traders, people living in remote areas and the harsh weather conditions of the, for example, Northern Europe, began to taste the richness of life enjoyed by the people of Southern Europe or the Mediterranean and Arabia. Consequently, the volume of trade and the level of interaction between the people of these faraway countries grew. This growth, people belonging to different national communities begin to learn more about lives and cultures of the people of foreign nations. This was beginning to for the first phase of the globalization, as we call now, and the challenge for law, its first challenge for law, which would later be termed as an international law. And challenge for law was to regulate the relations of people living under different sovereign entities scattered all over the world. When societies began to organize themselves as political entities, those common aspirations began from alliance giving rise for the formation of the states. And the most powerful and ambitious rulers strove to bring as many states as possible under their sway to create vast empires. Such empires needed massive amounts of wealth to sustain them. On the basis of the wealth that they amassed, imperial rulers embarked upon breathtaking projects in different spheres of human activity, ranging from the building physical infrastructure, such as palaces, castles, monuments, roads, and bridges, to promoting arts and culture. However, in time, these empires began to crumble under their own weight of the wear by any large. Artificial entities held together on the basis of force and oppression. The nations and people living under the empires began to assert their freedom, and this process ultimately gave rise for the birth of modern nation states in Europe. And the next step is the Peace of Westphalia of 1648 was a major landmark in the history of both international law and international relations. It was this treaty which acted as a catalyst of downfall of the Holy Roman Empire and the birth of the modern nations in Europe. The second step for us is stepping from the empires to the modern nation states. And when these nation states became organized, they too began to see whether the world outside of their boundaries offered any opportunities for wealth creation and the betterment of their people lives. Various missions were commissioned by these nation states to explore what lay beyond the vast waters of the ocean to the east, west, and south. These explorers and adventurers who set off from their European homelands and their journeys to unknown territories were to return with the exciting tales to tell about faraway lands, together with the samples of exotic items collected during the missions overseas, inside the rules to populace of the country to embark even bigger overseas missions. And this was the beginning of the second phase of the globalization and empire creation by the nation states. These explorers and adventurers became the catalyst for profound change in the international relations. In the centuries to come, people living in Western Europe were now in active and direct contact with the people of the Asia, Africa, and America. The Europeans grew to like the richness of life enjoyed by the people of Arabia, Southeast Asia, and Far East, and the volume of trade between these faraway territories began to grow. With trade came missionaries to spread their religion, and with the help of traders, missionaries, adventurers, and explorers, the nation states of Western Europe began to create their own empires by colonizing the newly discovered lands. This global interaction between the native people of Asia, Africa, Latin America on the one hand and the Europeans on the other was the beginning of a new phase of the globalization. And it's called the third step in the colonial era. And also after that we have the effect of decolonization. It was during the period of colonization that international law began to evolve enormously as a body of law that governing relations between states. The first phase of international lawmaking was Eurocentric and was designed to regulate affairs among the European powers themselves. The colonial powers were often at war with each other, but their relations had to be regulated and to ensure some degree of peace at home. Their relations vis-à-vis the colonial territories overseas also had to be regulated, so that were the smooth colonial rule. The Congress of Vienna of 1815 and the Treaty of Versailles of 1919 were designed primarily to settle disputes between the warring states of Europe. The establishment of the League of Nations, together with the creation of Permanent Court of International Justice, or now it's called ICJ, and the International Labour Organization, marked the beginning of new phase of the globalization. These organizations and these institutions sought to identify and advance the common values of the international community based on the desire to institutionalize peace between countries. Also bound by the rules of the Covenant of the League of Nations and the provisions of General Agreements of Peace of 1928, also and spirit of the international community of nations emerged, and the objectives of the community were to act for the betterment of humanity. However, the colonial powers were in fierce competition with each other for dwindling world resources. In order to meet the economic aspirations of their rulers and populations, competition for wealth among the European powers and the desire to bring as many colonial territories as possible within their control led to many wars among them, including the First and also the Second World Wars. And when the First War weakened the capitalist countries of Europe, they restored their protectionist measures to defend their economic interests rather than promoting the ideals of free trade for peace. Therefore, the interwar period was a time for economic disorder among the different capitalist countries on the other hand, and between the capitalist countries and newly independent states on the other. The spirit of the community of nations suffered huge setback when the Second World War broke out in Europe. Moreover, during and prior to the outbreak of hostiles in Europe, nations under colonial rule elsewhere were struggling for independence, just as nations within the old European empires had sought freedom from their imperial rulers. So nations under colonial rule began to assert their freedom from that rule, and consequently, various waves of independence gave freedom to nations under colonial rule. The independence of the Latin America states was followed by the independence of many Asian, African countries, which started gaining their independence in the aftermath of the Second World War. The independence of these countries posed new challenges to international economic relations, as they sought to attain their own aspirations and ambitions. As these newly independent states started to assert their sovereign rights, they came into the conflict between the interest of those foreign powers who had an economic interest in their territory. For instance, when the newly independent states of Latin America asserted their economic sovereignty by claiming that their national laws would apply to foreign investors, the Western countries challenged this assertion. The argument advanced by the investor countries was the international law, or more precisely, international minimum standards. Rather than national law applied to foreign investors, it was against this backdrop from the norms of modern international economic law began to evolve, and the Eurocentric nature of international law began to acquire global character. It was also during the phase of international lawmaking that international law sought to regulate not only economic relations, but also relating to this disarmament, the use of force, the conduct of states during time of war, the peaceful settlement of disputes. And the Latin American countries gradually came to accept international minimum standards in their treatment of foreign investors through the various human rights instruments relating to the Americas. By contrast, the newly independent states of Asia and Africa were more assertive for the economic sovereignty and attempted to rewrite the existing international law concerning economic relations through the platform provided by the United Nations. However, the capitalist countries resisted this tendency and sought to defend the existing rules of international economic law, which mostly served the interest of capitalism. Soon after the establishment of the United Nations, two camps of states, one led by the United States and the other by the former USSR, became locked in a Cold War that lasted for nearly 40 years. During this time, a polarized form of globalization was in existence in 1989, 1990s. The free world of capitalism, democracy, individual freedom triumphed over the communism, and new phase of globalization now began. This current phase has been the most comprehensive and also all-encompassing so far, bringing about far teaching changes in almost all sphere of human activities. So here I want to ask you about: do you feel the soul of the globalization? For example, globalization in the no, we are the bright example. We are now talking between the countries, between us, thousands of miles and miles by the land and seas. But do you feel the globalization and I think globalization of community in international world? Yes, please.
I'm, for example, World Bank. World Bank
Uh-huh.
controls the banks in the world. I think so.
Yes, it's right. The World Bank now is gaining control about.
Organization.
Yes, most of the transactions between the states and between the international organizations are transferred from the World Bank, and now it's the massive body of law also, and that's why now in the international economic law also some humanitarian globalization teachings, some scientists going to start the new field of law, and also it's called the World Bank or WTO law, because some uh, the uh, the more the countries are involved in the globalization process, The more transactions of the bank and money waves from the country to country by the private companies and also by sovereign states. That's why you pointed out that now the WTO, the World Bank has started their own field, but now it's part of the international economic law. And if you're interested in, I can give you some internet resources for also United Nations library, where some experts from the United Nations give the lectures about the international economic law and also about the WTO and the World Bank law. Okay, now we can move on. The number of independent developing states after the 90s grew dramatically, but this process was started in 1950s and 1960s, thanks to the success movements in Asia, independence movements in Asia, Africa, Pacific, and the Caribbean. The economic order created in aftermath of the Second World War, with the establishment of the Bretton Woods institution and also World Bank, the International Monetary Fund, and also general agreement on tariffs and trade, and it's called also GATT, and was no longer capable of fully addressing the world's economic problems in the exchange context. Before GATT between the states was the Bretton Woods institution, and I would like to show you the video on YouTube too about to understand what is a Bretton Woods institution. Mm-hmm. Yeah, it's working out. Let's see.
After World War II, it was clear the world needed a new financial system. The gold standard was considered too rigid, but at the same time, economists were worried that countries would devalue their currency to boost exports. For this reason, 44 countries sent delegates to a conference held in Bretton Woods, New Hampshire, as of the 1st of July 1944. The US, which held 2/3 of the world's gold reserves after the war, was obviously the most influential player, and ultimately, all currencies ended up linked to the dollar, and the dollar was linked to gold. One important concern arose, though. If a country goes through an economic crisis, how can it get out of it without devaluing its currency? To address this issue, two institutions were created. One, the International Monetary Fund, which was supposed to lend money to countries that are in trouble and cannot attract financing from other sources. Two, the International Bank for Reconstruction and Development, which is now called the World Bank and was supposed to help less developed countries grow. Unfortunately, as good as it may have sounded on paper, the Bretton Woods system didn't survive because the United States kept running deficits to fund various projects, and therefore the amount of dollars in existence kept increasing while the gold reserves of the US kept shrinking, as more countries demanded gold in exchange for their dollars. As such, on the 15th of August 1971, Nixon officially announced that dollars would no longer be convertible to gold, thereby putting the final nail in the coffin of the Bretton Woods system.
And as you see, the first step between the globalized states was the Bretton Woods institution. And after that, the next step and the next period of time was GLTT, General Agreement on Tariffs and Trade. 1947 was premised on the idea of creating a level playing field in the conduct of the international trade. This was not acceptable to the newly independent developing countries which sought help from the international community to be able to compete on equal footing and also benefit from the GBLIT regime. What is more, the developing countries did not confine their aims to changes to the GLT system, but had much more ambitious dreams for themselves. They sought to restructure the whole international economic order in order to bring out international justice and cherished goal of the international community outlined in the preamble of the Charter of the United Nations. Consequently, the decolonization period of 1950s to the 1960s was characterized by the conflict on both the economic and political fronts between the developed and developing countries. When the newly independent states of Asia, Africa started acting jointly with the Latin American states, they embarked on a policy designed to achieve economic equality between states by proposing a restructuring of international economic relations. And that tense that made of 1960s, 1970s within the United Nations to define the nature of the legal relationships between the host state and foreign companies sought to define the competence of sovereign state and to expropriate and regulate foreign companies operating within. They didn't seek to regulate the unhindered exploration of natural resources by states themselves. With the exceptions of the United Nations resolution of 1962, designed to endorse a call by UNESCO to enact effective domestic legislation to preserve natural resources, including flora and fauna, the emphasis was very much on establishing the right of states in international law to exploit their natural resources in accordance with their own development policies. As well as various international economic law instruments, various human rights instruments adopted in the period from the 60s to the 80s sought to establish and strengthen the right of states and people freely dispose of their wealth and natural resources. Examples include the 1966 International Covenant on the Civil and Political Rights, 1960s International Covenant on Economic, Social, and Criminal Rights, 1981, it was for African Charter on Human People's Rights. Even the resolutions of United Nations concerning the new international economic order and the Charter of the Economic Rights and Duties of States adopted in the mid-70s during the heyday of the triumph of the third world countries within the United Nations, but this didn't introduce the element of sustainability or any need for countries to consider the environment while engaging in the exploitation of their own natural resources. Thus, traditionally speaking, the idea of sustainable development or the need to conserve natural resources was missing in the main corpus of international economic law. It was only through developments taking places elsewhere, mainly in the area of international environmental law, that the idea of sustainable economic development and the need to conserve natural resources was introduced onto the agenda of international economic law. The Charter of the United Nations, or how we call in Russia, is World Constitution, entrusted the United Nations and with the overall responsibility for formulating policies designed to, firstly, it's achieve the highest standards of living for the people of the world, and the second, address problems of the economic character. Consequently, United Nations began to work from the quite early of the economic development of developing countries, and it didn't supply react to economic events, but was also proactive in formulating policies designed to address the problem of the underdevelopment. The activities of the United Nations and its specialized agencies in this regard have evolved in phases as follows. During the first phase of the United Nations, between the establishment and the late 50s, its activities focused mainly on development of the human resources of developing countries in providing technical assistance for them. The number of developing countries was small and their ambition was limited. By providing assistance was seen by both the United Nations and developing countries as the starting point for the further their development. Also, the absorbing capacity of the developing countries was limited. What they need in the early stage of the economic development was technical assistance in the form of expert manpower and related assistance. As the number of developing countries grew within the United Nations, thanks to accelerating decolonization, they started to assert their economic independence and champion a more just, fair world economic system. Between the 50s and the late 60s, the international development agenda moved from providing technical assistance to creating institutions, such the United Nations Conference on Trade and Development, and formerly called UNCTAD, to ensure that the international institutions took the needs and aspirations of developing countries more seriously. Developing countries began to challenge some of the existing principles of international economic law in favor of systems which met their aspirations. In doing so, they wished to introduce some reform to the Bretton Woods institution, especially within the GATT system. They also wished to introduce the development agenda into the system. And the next phase was restructuring the world economy. 60s was an exciting decade. Rising human expectations and ambitions. People saw it was possible to go to outer space, to reach the moon, and towards to the end of the decade, the world came to know that there was a huge reserve of mineral resources in the deep seabed. It was during this decade that a larger number of states gained independence. Many of them give little or no bloodshed. It was a positive or progressive time in many aspects, but it was tumultuous. The Cold War reached new heights. Two superpowers, although they came close to nuclear war during the Cuban Missile Crisis, and developing countries sought to restructure the world economy through the United Nations. And the third world countries asserted themselves. During this decade, the gap between the rich and poor widened dramatically. The nations that had gained independence realized that the world economic order was not conducive to their economic development. Encouraged by the numerical majority that they had now acquired in the United Nations and the solidarity that they enjoyed, the developing countries decided to pursue proactive policy aimed to the redistribution of wealth through the United Nations. The idea was first to help the unilateral expansion and exploration of the world's resources by a few technologically advanced and economically powerful countries, and then to introduce rules designed to achieve equality of opportunity and justice for all. Consequently, 1967 Treaty of the Outer Space sought to prevent unilateral claims over the outer space and celestial bodies by those with the technological ability to travel in space. 1970s Declaration of the Common Heritage of the Mankind sought to halt unilateral claims over areas of the deep seabed and unilateral exploitation of the resources of them. When the developing countries gained a numerical majority in the United Nations, they sought to use this United Nations system to introduce much more fundamental reform to the international economic system. In the sense of the 70s was the heyday for developing countries, as I've said before, and saw strong solidarity among them. They were encouraged by the oil crisis of the early 70s, during which oil exporting developing countries sought to flex their economic muscle. It was in the 70s that this non-aligned movement for the mainly third world countries gathered some momentum, and the idea of South-South cooperation was treated as a serious proposition. Thus, 70s were the golden decade for developing countries, a time of political triumph for them. And now we are going to the new international economic order. While both Eastern and Western countries were competing for influence and trying to win over the third world countries' friends for their bigger political, military, and strategic objectives, there was no strong opposition initially from the developed countries to ambitious proposals from the developing countries. In fact, much of socialist world sided with the aspiration of developing countries and many capitalist countries with some socialist values as the Scandinavian countries, the Netherlands, Canada, Australia, New Zealand, had some sympathy for the developing countries' position. It confronted with the changed situation, and the leading developing countries appeared to be in a state of confusion in their approach towards to the developing countries. The developed countries were still seeking to redefine their position vis-à-vis the developing countries. And many of the powerful developed countries had either liberal or pro-human rights governments in the 70s, so couldn't mount or outright opposition to the attempts of developing countries to create fairer and more just international economic system. And the developing countries were not satisfied with the reform of general agreement of tariffs and trade system, and they were not content with the failure trade regulating mechanism. They wanted to challenge the focus of the existing international economic institution from regulating institution to more proactive institutions, which would actively promote the ideas of the international economic justice through redistributive international economic system. Eventually, the developing countries' radical approach met with the resistance from the developed countries. From the on, the United Nations was divided into two camps: developed countries and developing countries. Since the developing countries had a numerical majority, they pressed ahead with the resolutions within the United Nations, but it was aspired to restructure the world economy. This approach was represented by the notion of the new international economic order. And while the notion of the new economic order was still on the international agenda, a powerful counter-movement spearheaded the capitalist agenda in much of the Western world. This counter-movement was based on privatization, marketization, globalization, and also liberalization of the economy had less government both nationally and internationally. And by the early 80s, China had decided to embark on economic liberalization and openness. And during that decade, other leading developing countries such as India, Zambia, which had up to now believed in a mixed economy and had socialist tendencies, decided to abandon their traditional policy and jump on the capitalist bandwagon. Much of the developing countries found itself a state confusion during the much of the mid-80s, as many countries realized that their old economic and political ideologies were not improving their economies. Third world solidarity was disintegrating, and developing countries now found themselves competing with each other on the ticket of foreign direct investments that was flowing from the developed countries. Consequently, in the late 80s became a period of political uncertainty and economic confusion in many developing countries. As the developing world began to embrace the capitalist agenda, the communist world in Eastern Europe came under tremendous pressure to open up its doors to the outside world. A realization of the part of the Soviet Union that it could not go shouldering the huge economic burden of the Cold War. While the countries, including its giant next-door neighborhood China, pursued economic prosperity, led to the collapse of the communism in Eastern Europe and after the fall of Berlin Wall. And also the Soviet Union simply caved in under the pressure of capitalism. It could not sustain the arms race, nor could it go to extending an expensive protective military umbrella over much Eastern Europe. The very reasons that led to the withdrawal of the Soviet Union from satellite states and Eastern Europe acted as a catalyst for disintegration of the Soviet Union empire itself. The chaos that ensued resulted in disarray right at the heart of Kremlin, relegated Russia, the core of the Soviet Empire, to weak position. Ripples from the gigantic democratic revolution in Eastern Europe and the changes in the Central Asian countries and republics spread to many Asian and African states. This brought down the old regimes, installed new regimes, some democratic and some semi-democratic. And after that, as we know, we now living in this age, the height of the corporate power. In the 90s, in the late 90s, represented the return of the golden age for capitalism. There was huge swing from the 70s heyday of the developing countries to the 90s. During this era, capitalist countries led by the United States, United Kingdom, came to dominate the world, both politically and economically. The 90s offered free marketeers and multinational companies unprecedented opportunity to expand. The 90s and the WTO, the World Trade Organization agreements, concluded the end of the Uruguay round in 1993, reflected to the triumph of capitalism over the socialism and the ideas of mixed economy. While Russia attempted to recover from the disorder from the early 90s, China was quietly leaping forward to the road of economic prosperity. The disintegrated third world was still seeking to emerge from chaos and confusion. This gave to the developed countries the unprecedented opportunity to stamp their own authority on more or less every area of human activity throughout the 90s. Consequently, 90s became the most ambitious decade in recent times for the globalization of the Western ideologies, both politically and economically. But, however, the triumph of capitalism and the absence of any credible opposition to the activities of multinationals and free marketers led to the excesses. The domination of the world by the big business, their pursuit of profit and the expense of the human rights, the environment, moral and ethical value gave rise to the opposition. Academics, other intellectuals, environmentalists, human rights activists, and other campaigneers from the era around the world were united in their opposition to the excesses of the capitalism. In the late 90s, they mounted huge and often success protests. This time opposition came not from the developing countries, not from the socialist camp, but from within many capitalist countries. And consequently, the World Trade Organization was forced to abandon in the Seattle Conference in 1999. Both the World Bank and the International Monetary Fund faced widespread opposition to their policies in the 90s, which led to a more balanced approach to world trade by the time that the World Trade Organization met in Doha, Qatar in November 2009. Now I would like to give you some break, for example, 10 minutes. Is it okay for you? To get some cup of tea and rest from the mind, blah, 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 about the international economic disorder. Please rest yourself for 10 minutes. I will meet you after the 10 minutes and we continue our lecture. Okay? Great. Dear participants, please turn on your cameras. And we'll continue the lecture now. Oh, yeah, great, thank you. I hope you now were helped by my history of the international law. Now we're going to, okay. Do you see the presentation? Yeah, great. And let's continue the talk, but now not about the history. Now you do know about the history. Oh, also, I wanted to admit that the organizers really do worry about you and about your representation here in the international school. It's really great, and I hope you enjoy that. And now we will continue by the more jurisprudence terms, more law information, because now you know about the prehistory of the international economic law and what was the reasons to endorse and to organize the international economic order, and also about the steps between the first step of the international merchant and now the all global international economic. And now we will talk about the definition of the international economic law. International economic law, as you understand, regulates the international economic order or economic relations among nations. We will talk about so. However, the term international economic law encompasses a large number of areas. As I said before, and if you remember about the WTO law or World Bank law, and is often defined broadly to include a vast array of topics ranging from the public international law of trade to private international law of trade, to certain aspects of international commercial law, and also the law of international finance and investment. The international economic law interested group of the American Society of International Law include the following non-exhaustive list of topics within the international economic law. It's firstly international trade law, including both the international law of the World Trade Organization and domestic trade laws. Secondly, international economic integration law, including the law of the European Union, Mercosur, NAFTA. Thirdly, is international private international law, including the international choice of law, choice of forum, enforcement of judgments, and the law of international commerce. For the international business regulations, including antitrust and competition law, environmental regulation, and product safety regulation. Also, here include the international financial law, including private transactional law, regulatory law, the law of foreign direct investment, international monetary law, including the law of International Monetary Fund and the World Bank. Also, the international economic law research the role of law in the development, international tax law, of course, and international intellectual property of law. And the basis of the international economic law and all international law, public international law, based on the traditional principles of international law, such as pacta sunt servanda, freedom, sovereign equality, reciprocity, economic sovereignty. It also based on the modern and evolving principles such as the duty to cooperate, permanent sovereignty over natural resources, preferential treatment for developing countries in general and the least developed countries in particular. The source of international law, as I said in first part of the lecture, is the same as those sources of the international law, generally in Article 38 of Statute of International Court of Justice. Its international conventions, whether general practice or particular, establishing rule expressly recognized by states, international custom as evidence of general principles of accepted as law, the general principle of law recognized by nations, and also judicial decisions and teachings of the most highly qualified publicists of the various nations, but it's used by only as a subsidiary means for the determination of the rules of law. And you may ask me, what is economic sovereignty? When states began to function as political, independent, and sovereign entities, they realized that one of the most attributes for state sovereignty is economic sovereignty. Without this, political sovereignty wasn't complete. Asserting economic sovereignty means having control over the economic activities of both juridical or natural persons concluding business within the country, whether nationals of the country or foreigners. Owing to a number of historical reasons, many states inherited an independence situation in which foreign individuals or companies enjoyed certain concessions or privileges or control of the economic activities of the country concerned. In many states, foreign companies or individuals controlled the natural resources and mining rights under a concession agreement entered into the previous administration, whether colonial or otherwise. When the country concerned wished to embark on the policy of economic development, one of the first initiatives it had to take was to consider harnessing its natural resources in accordance with the economic policies. Yeah, it therefore became necessary for these states to assert the sovereignty of the natural resources of the country and require that foreign individuals, companies comply with the new policy adopted by the state. In many countries, it was difficult to assert economic sovereignty without doing away with the rights, concessions, privileges enjoyed by the foreign individuals and companies over the country's natural resources. However, developed countries whose nationals had gone overseas to invest and do business resisted attempts to impose national law on foreigners. They argued that the existing concessions and contracts had to be honored under international law. It was a juncture that the concept of permanent sovereignty of the natural resources and was introduced as the international law. And also, no exception for the economical sovereignty is permanent sovereignty of the natural resources. When the number of newly independent developing countries grew, these states sought to assert their complete economic sovereignty by proclaiming that they had to complete and permanent sovereignty over the natural resources, regardless of any arrangements made by their previous colonial administrations. Consequently, a resolution was introduced in the United Nations General Assembly to this effect and was passed by the overwhelming majority of states, and it's famous for the 1962 United Nations General Assembly resolution on the permanent sovereignty of the natural resources. And the first article of this state that the right of people and nations to the permanent sovereignty of their natural wealth and resources must be exercised in interest of their national development and also the well-being of the people of the state concerned. The exploration, the development, the disposition of such resources, as well as the import of the foreign capital required for these purposes should be in conformity with the rules and conditions which the peoples and nations freely consider to be necessary or desirable with regard to the authorization, restriction, prohibition of such activities. Accordingly to the resolution goes to the outline it rights of states with the regard also the exploitation and nationalization of the assets of foreign companies. Nationalization, exploitation, and requisition should be based on the grounds of reasons of public utility, security, and the national interest, which are recognized as the overriding purely individual of private interests, both domestic and foreign. In such cases, the owner shall be paid appropriate compensation in accordance with the rules in force in the state taking such measures in the exercise of its sovereignty in accordance with the international law. In any case, where the question of compensation gives rise to controversy, the national jurisdiction of the state taking such measures shall be exhausted. However, upon agreement by sovereign states and other parties concerned, settlement of the dispute should be made through arbitration or international adjudication. The concluding paragraph of the resolution seeks to assure investor countries and foreign investors that provisions of bilateral investment agreements will be respected and foreign investment agreements freely entered into by or between sovereign states shall be observed in good faith. States and international organizations shall strictly and conscientiously respect the sovereignty of people and nations over their national wealth and resources in accordance with the Charter of the principles set forth in the present resolution. The provisions of the resolution have been held widely and representing customary international law because of the unanimous support it received from the United Nations and its declaratory nature of the rules of customary international law on the subject matter. Uh, as you see, fundamental principles of international economic law and attempts to implement the objective of the new economic order and to establish norms of international economic relations, the United Nations of the General Assembly adopted as a part of its revolution on the new economic order, the Charter of Economic Rights and Duties of States in 1974. Chapter of this charter outlined that the fundamentals of international relations in the following worlds: economics, as well as political and other relations among states, shall be governed inter alia by the following principles: sovereignty, territorial integrity, and political independence of states, sovereign equality of all states, and most important, non-aggression, non-intervention, mutual equitable benefit, peaceful coexistence, equal right and self-determination of peoples, peaceful settlements of disputes, and remedying injustice which have been brought about by force and which deprive a nation of the natural means necessary for normal development, fulfillment in good faith of international obligations, respect for human rights and international obligations, no attempt to seek hegemony and spheres of influence, promotion to international social justice, international cooperation for development, free access to and from the sea by land, locked countries within the framework from the above principles. These are principles of general nature which include both economic and political principles and reflect the trend of the early 70s. And it's outlined the rights that every state has sovereign and unalienable right to choose its economic system as well as political system, social or cultural system in accordance with the will of its people without the outside interference, coercion or threat from the whatsoever. Every state had and shall freely exercise full permanent sovereignty, including possession, use and disposal over its wealth, natural resources, and economic activities, Each state had the right to regulate, exercise authority of foreign investments, to regulate and supervise the activities of transnational companies or corporations. Every state should, with the full regard for its sovereign rights, cooperate with the other states and exercise the rights set forth as subparagraphs of this declaration. Also, every state has a right to engage the international trade and other forms of economic cooperation, irrespective of any deemed difference in political, economic, or social system. No state shall be subjected to discrimination of any kind based solely on such difference. In this pursuit, international trade and other forms of economic cooperation, every state is free to choose of forms of organizations of its foreign economic relations and to enter in multilateral agreements, arrangements, constituting some international obligations and with the needs of international economic cooperation. Although this declaration was not a hard law, entrustment having binding legal effect. Many of the principles embodied in it have been regarded as representing the basis for the development of international economic law. Indeed, the character reiterates some of the principles that were already widely accepted by represented customary rules of international law, such as permanent sovereignty of states over their natural resources. But the right to economic development is one of the central elements of the new economic order. And one of the central of this part is economic development of states. This element was reinforced and strengthened through the 90th resolution of the United Nations General Assembly and to the right to economic development of the states. The main provisions of this declaration read as follows. The right to development is an unalienable human right. Also, the human right to development also implied the full realization of the right peoples of self-determination, which is human rights, which include some provisions of international covenants of covenant of human rights. The human person is a central subject of the development and should be active participant and beneficiary of the right development. All human beings have responsibility for development, individually and collectively, taking into account the need for full respect for their human rights and fundamental freedoms, as well as their duties to the community, which alone can ensure the free and complete fulfillment of the human being. And they shouldn't therefore promote and protect an appropriate political, social, and economic order for the development. States have the right and also duty to formulate an appropriate national development policies. Although the right to the development is a difficult right to define in concrete terms and doesn't have much legal significance, the articulation of this right in 19th had the principle of international trade and development and enabled the international community to rely on support and develop of principle of international trade, special and preferential treatment of developing countries, and the need to address the problem of the international debt. It can also be argued that the right to development was a contributor to the adoption of the Millennium Development Goals by the international community. Have you heard about that? Millennium Development Goals for the community, for the human mankind. That's pity. So it was adopted in 2000 at the dawn of the new millennium, and also some law on natural resources, also the Stockholm Declaration of the United Nations was like the aims for the humankind to save the world and save the planet. The law of the natural resources is the most, I guess, important part of the international economic law. Maybe you know the Stockholm Declarations of the United Nations Conference on Human Environment, was perhaps the first major international environmental law instrument that introduced the idea of conserving natural resources onto the agenda of international economic law. Principles of the Stockholm Declaration speak for the need to conserve the uh, natural resources of the earth, including the air, water, land, flora and fauna, and especially representative samples of natural ecosystem must be safeguarded to the benefit of present and future generations through the careful planning for management. The capacity of the earth to produce vital renewable resources must be maintained and where practicable restored or improved. The non-renewable resources of the earth must be employed in such a way as to guard against the danger of the future exhaustion and to ensure that benefits from such employment and shared by the all mankind. The Stockholm Declaration sought for the first time to limit the right of states to exploit their natural resources, especially those which are non-renewable. As stated earlier, until this point, international economic law had sought to define and strengthen the rights of sovereign states to exploit their natural resources, whether they're renewable or non-renewable, through various instruments such as the concept of permanent sovereignty over natural resources. However, while endorsing this right of states, the Stockholm Declaration sought to reconcile it with the needs for the environmental protections. States have, in accordance with the Charter of the United Nations and the principles of international law, the sovereign right to exploit their own resources to their own environmental policies and the responsibility to ensure that activities within this jurisdiction or control do not cause damage to the environment or other states or areas beyond the limits of national jurisdiction. The next part is the Charter of the Economic Rights and Duties of the States, and it's included the following provision furthering the spirit of the Stockholm Declaration: the protection, preservation, and enhancement of the environment for the present and future generation is a responsibility to all states. All states shall endeavor to establish their own environmental, developmental policies in conformity with such responsibility. The environmental policies of all states should be enhanced and not adversely affect to the present or the future development or potential of developing countries. Also, all states have the responsibility to ensure that activities with their jurisdiction or control do not cause damage to the environment of the other states or areas beyond the limits of the national jurisdiction. Thus, the momentum was maintained within the international environmental and in international economic law to limit the right of the states to exploit national resources in the favor of the preservation of the environment. Consequently, the need to conserve natural resources and exploit them in a sustainable manner figured prominently in the World Charter for the Nature, for example. And the next point is the World Charter of the Nature, and it's declared that the man can alter nature and exploit natural resources by his action or its consequences, and therefore must be fully recognize the urgency of maintaining the stability and the quality of nature. Uh, the next point, I guess, would be the United Convention of the Law of the Sea. We need to pay attention to the preservation of the environment while exploiting natural resources was also reflected here in the Law of the Sea Convention adopted in the same year in the 80s. This convention provides that states have the sovereign right to exploit their natural resources pursuant to their environmental policies in accordance with their duty to protect and preserve the marine environment. Thus, from the 80s onwards, idea developed that the right of states freely dispose on their wealth of natural resources was the subject of concept of the preservation of the environment. conservation of the natural resources, and the sustainable use of the development of such resources. These concepts were also gradually finding their way into the body of international economic law. The principles of the international economic law relating to the exploitation of the natural resources, other environmental treaties, whether global or regional, uh, relating to the specific regions, for example, for Africa or for the Asia, or the protection of specific geographical areas, wetlands, for example, or specific natural resources, for example, wildlife, flora and fauna. And this all has started lending their support to the idea that the international economic law based right a state to exploit their natural resources, but was subject to certain principles of international economic law. And here we see the connections between the parts of the public international law, between the environmental law and in the economic law. The next step is Brundtland Commission. In 19th, it was a report of the Royal Commission on the Environment and Development, popularly known as the Brundtland Commission, popularized the phrase sustainable development, embodying both states' right to economic development and their obligation to pay particular attention to any degradation of the environment resulting from the development activities. In other words, it was a phrase coined to express the balance that had to be reached between the right of state to use and exploit their natural resources in accordance with the developmental policies and the duty inherent upon them preserve the environment in carrying out such development activities. The Commission defined the term sustainable development as the development that meets the needs of the environment in carrying out such activities. In opinion of the Commission, economic development and economic law and international economic law that undermine the environmental law led to the excessive exploitation of natural resources to the detriment of the future generation was not sustainable development. Hence, it was felt that the need to preserve and make rational use of the natural resources of country in the interest of environmental and future generations was inherent to the concept of sustainable development. And I guess the last point for the connection between the economic law and environmental law, it's a Rio Conference, 1992. Following the groundwork done by Brundtland Commission on broad concepts such as sustainable development that embraced not only the environment but also all other economic activities regulated by economic law, United Nations decided to convene a special conference on environment and development in Rio in 1992. Unlike the Stockholm Conference, which was on the human environment, the Rio Conference was going to consider both the environment and development, displaying the importance attached to the elements embodied in both words. And Principle 1 of the Rio Declaration on the Environment declared that human beings were at the center of concerns of sustainable development. And this declaration of the Rio was adopted unanimously, the largest conference ever convened in the history in international relations. It seeks to recognize the right of states under international economic law to exploit their own resources pursuant to their own environmental policies, and the duty of states in international environmental law to ensure that activities within their jurisdiction or control do not cause damage to the environment of the states or the areas beyond the limits of national jurisdiction. The language used in this declaration in the provision of the most declarations and United Nations provisions that was adopted by from the 50s to the 19th. And the law of sustainable development has brought these two branches of law, such as environmental and economical, together. adding a sustainable development dimension to various principles of international economic laws, such as equity, the right to economic development, the right of permanent sovereignty of states over the natural resources. Although the Rio Declaration widened the scope of the principle of sustainable development to include not only conservation of natural resources, but also of other elements that gave this principle a credible international standing. Um, and in the end, traditionally speaking, the international economic law now in the modern age, in the modern decade, didn't pay much attention to environmental concerns. International economic law for the harm done to the environment by these activities. To maintain international economic agenda and institutions for the post-Second World War period involved promoting the free movement of goods and capital across borders and enabling states to exploit their natural resources to the maximum extent possible for the economic development. International economic law tried to catch up with the expansion of international economic and also commercial activities to regulate whether and whichever aspect possible, but without paying much serious attention to the environmental aspects of economic development. However, more recently developments taking place with the international environmental law connected to international economic law influence the development of international economic law. And the new idea also sought to unite both the developing and developed countries in a pursuit of common agenda. Implicit the idea of sustainable development was that the developing countries would receive a financial assistance from the developed countries to carry out developmental projects which do not harm to the environment, take into account concepts such integrational equity. Oh, sorry, there is some. I see some sound from someone. Yeah, great. Also, the development agenda of the world was no longer supposed to be a struggle between developed and developing countries. Rather, both groups of states were supposed to work to jointly to achieve sustainable economic development. All states had a duty to contribute to the process, and different conference and instruments adopted by United Nations. This is historical background to the development in modern times of international economic law. As we can see, the history of international economic law is basically the history of interplay between law, international politics, and the environment. And its heart have been the national interest for the major powers of the day and the desire to fashion international economic law to suit their priorities. But now international economic law simply refers to the rules governing to cross-border movements of goods, people, technology, financial capital, as well as the institution created to design and enforce such rules. International economic law has, over the past 3 decades, developed exponentially as the field of study, evolving from the subfield of public international law into a multi-layered, highly specialized discipline for its own, encompassing areas such as trade, investment, finance, environment, intellectual property, business regulation, energy, and also competition law. As an area of scholarship, policy, practice, international economic law has largely been dislodged from the broader social, economic, political, ecological, and historical context in which it operates, at the heart of the current global order are profound dislocations between the economy, society, and the natural environment. Also, the coronavirus COVID-19 pandemic that has brought the world to halt this year, the past year, clearly reveals brutal manifestations of these dislocations. Some while the pandemic spreads and the unprecedented speed, leaving behind a devastation that we are only beginning to comprehend. And the current pandemic and the responses to it by both states, communities, companies are bringing into sharp focus of the international economic role in setting in motion of particular kind of social, political, and economic globalization, in which, for example, the world billionaires have more wealth today than the 60% of the world population, and where the 22 richest men in the world have more wealth than all the women in Africa. This last point is crucial given the Moon and Africa beyond make up at least two-thirds of the global care workforce. And in times of multiple pandemics, uh, population will remain in forefront of the governmental and community response. Uh, in this intervention, we as participants of the international economic law every time, everywhere, reflect on the ways that underline with the problematic patterns of globalized production and consumption underpinning of the slow responses and rapid spread of the pandemics, for example, and the ways in which we could respond to the crisis in more globally just and a sustainable way. So for today, I guess it's over. I hope that I do not overwhelm you very, very much for this evening. I wish to you, the participants of the school, interesting discussions, productive work. I'm sure that the school will be a significant event for you. I'm Thank you so much for taking part in my lecture. It was great pleasure to discuss with you international economic law. If you have a question, if you have some problems and you would like to write down some article or know about something international law activities in Russia, especially in our Samara University, please contact me. I will now. I will. Oh, I forgot my email. I will leave it on the screen now. Uh, no, not this. Give me 1 second, please. I will check my working email. Yeah, right. This one. Have it more bigger for you. If you have any questions, if you would like to continue our discussion, please write down some letters for me. And also, my lecture is enough. The organizations give me only 2 hours. I would like to talk more, but I know you really need to have a bit time. Please,
Yeah.
we have 2 or 3 minutes, maybe some questions of you, please. Do not hesitate.
Dear teacher Ruslan, thank you for your lesson class. In 2005, I finished accountancy faculty, school.
Mhm. Sorry, could you repeat your question, please? Some troubles with my speakers.
In 2005, I finished accountancy school in Mexico City.
Oh, seriously?
Yes, I have a diploma.
Oh,
I
that's great.
attached in Facebook, my Facebook page.
Oh, we will try to connect. That's really really great. Also, I would like to ask some questions about your mood. What's your mood about the international school now? Do you like it?
Yes, I liked it very much. I am proud of joining international school, making friendship, uh, and discussing topics, learning about necessary materials, about details of international law, and
Great.
uh, it gives enjoyment, inspiration to listen to our dear teachers. Thanks a lot.
Thank you for you because you are great listeners. We would like to work for you every time. And Pirayo, Leonardo, do you want something to say?
I have actually a little question.
Okay.
For example, in the international economic law, due to the coronavirus crisis, what is for you, what is the best instrument, for example, for underdeveloped countries to get support? Like, for example, I don't know, maybe the World Bank or the other institution, how they could support them, because actually a lot of people say that there is no money in the world, and now with the Biden presidency, we don't know what's going to happen. So what is going to happen, how the underdeveloped countries could recover their economy, or which instrument?
Thank you for your questions. It's really complicated question because uh, not only pandemic of the past year and current year is affecting to the international relation on international economic law. There's many problems between the political and politics from the example two camps of the United States and Russia and China. Also some problems with the Brexit with the United Kingdom and the European Union. That's why this complicated field of the problems going hard to the not only economic law, but all the branches of public international law. I guess I'm not a part of international organization, and I'm not a subject of this. But I guess some international organizations will have some recovery funds. I know about the International Monetary Fund and etc. has some recovery funds for the developed countries. But I thought about it a long time ago, and I guess it wouldn't help to all countries all over the world. Firstly, we need to give us some recovery fund to international organizations that give help with the medicine, because especially in the theme of the COVID-19 and the pandemic, it will be great choice to support some international organizations and some international medicine or some scientific medicine schools that are going to figure out about the vaccine and how to restore our the wealth and health from the in the European Union, in Russia, in Latin America, in all other countries. And For me, the humanitarian people, I really, really, really hope that this pandemic will not destroy some international connections between countries, because the, the the really benefits of that globalization that we have now is the connections between the developed countries and developing countries, and through the interconnections between people. And I really, really hope, and I do hope that not also politics, not only pandemic, and not only reasons of the pandemic will have like due to the other connections, and connections between countries, first of all, and connections between country to international organization, and connection between the international organization in international organization. For me, the first step is take the recovery funds, and first of plan is give the money to the organizations and people who are going to research the vaccine, and this vaccine would be, the payroll, and this vaccine would be free to all people throughout the world. It's not the opinion of the man that had some economic studies, but it's opinion of really of the humankind. That's that like.
Thank you very much. Yes, you're right about that. Actually, it's like, yeah, we need business, we need connections, globalization. It's like, for example, I don't know why the countries close the borders, no? In the first hand, I was very angry when Mexico doesn't close the borders. It was like, come on, Mexico, why are you waiting? Europe closed the borders, USA closed the borders, every country closed the borders, no? But then after the time, I understand that was the best decision that to don't close the borders in Mexico, no, for all the countries, because thanks for that, we became from the sixth place of the most visited countries in the world to the third place in this year, the third most visited country in all the world. No, it was like, okay, we need tourism because we don't have the economy like Russia or like Germany or the European Union or the USA, no, or China. And now, thanks for that, a lot of people is taking food to their houses now because we have tourism now. Yes, we have the COVID, but we need the business, we need the connections, we need this economy support. Every country need it. So maybe yes, the best option to, I think that my point of view, the best option in this year to grow out the economy is to open the tourism again in all the world. Because, for example, Russia has a lot of tourism too, and they had a lot of income for the tourist people. But we don't know what's going to happen now. It's very uncertainly this year.
Yeah. Yeah, but I hope that 2020, 2021 will be more better. We will be better than the 2020.
Yeah.
I hope so, and maybe the portals will open in I don't know, maybe in 1 year or another. It will depend from the pandemic situation in countries, and we need to strengthen now. We need to not become angry and not become the opposition of the political force that want to help us. I hope the situation uh, will be normalized in the nearest time. I hope so, but we will see. We will see. Okay, if there are no any questions, I really, really thank you for your listening. It was great time for me to hear international economic law. Thank you very much again, and
Welcome.
I wish you good luck, and
Thank you.
please stay home and stay healthy in these hard times.
Thank you very much.
Thank you very much.
Goodbye.
Bye.
Goodbye.
Bye bye.